Thank you, everybody, for getting back to the seated. Our next speaker is Brittany Antonacci, who is the acting district attorney in Cayuga County. Brittany took office January 1st when her boss took a position as a surrogate court judge in Cayuga County, and Brittany is the first woman to be district attorney in Cayuga County. There's a saying in the law, which those of us who've been in the business for a long time know is absolutely true and irrefutable. There is only one way to become a good trial lawyer, and that is to try a lot of cases. As many of you know, in the rural counties and suburban counties, there are not a lot of felony trials in those counties because there's not a lot of people with enough wherewithal to have trial defense, and there's not enough money on the prosecution side to do that. So with that, I get this sheet from Aunt Sean Marie to introduce this speaker, and I start reading it, and I realize that this person has been an attorney for just over 10 years, but she started out in the Albany County District Attorney's Office handling felony cases immediately. She became a supervisory attorney and trial attorney for the Albany County District Attorney's Office and had 6 years of experience there trying felonies. She also appeared in the appellate division and has argued in front of the Court of Appeals successfully. In 2018, she came to Cayuga County, bringing that wealth of experience. To date, she has tried over 30 felony cases. Virtually no attorney starting as a district attorney in upstate New York in the rural counties has any level of experience, anything close to that. That's important because it speaks to her qualifications, but it's also going to speak to the second point about this introduction. So when Brittany started, she came to the office being a very capable prosecuting attorney. You can't be a good trial lawyer without trying cases. She has that. But it also tells you a separate thing, which is about the reality of a district attorney's office. You also learn what cases are not good cases and are cases that are likely to chew up a ton of resources that will not allow you to have the resources for the good cases you already have to prosecute. So you have to know that you cannot make a bad case a good case, and you're better off not wasting your resources trying. Those are mistakes that all of us have seen in small counties where district attorneys who really aren't that good at trial lawyers go into these publicity cases and lose them and waste a lot of resources and get a lot of mud on their face. Cayuga County is extremely fortunate to have this district attorney. Here's the second part. Hold on. The second part of this is a very sad part of New York politics, and I hope all of you will listen to this. There's a very distinct possibility that this next week, Governor Hochul is going to remove her from office. Governor Hochul very well may remove Brittany from office this coming week. She is under huge political pressure to replace her with a Democrat. This Democrat has tried one trial case in his not distinguished career. And this person has no experience in the district attorney's office and is not capable of even beginning to reach the level of professionalism and judgment that is needed. It is absolutely hypocritical that the same governor refuses to remove from New York City the new district attorney who pledges he is not going to prosecute felony cases or misdemeanor cases that he doesn't deem are appropriate to be pursued. That is absolutely not what the statutory obligations of a district attorney are, and yet the governor will not remove that district attorney and wants to remove the first female district attorney from Cayuga County who has far more experience than any district attorney coming in that I can recently think of, and a person who is unquestioned integrity and who is trying to do the public good. So not only do I want you to listen to her speech today about what the effects of bail reform and other criminal procedure reforms have been on the justice system, but also think in the context of this coming week, if she is the person that's removed from office, that there needs to be a reaction across this state for this blatant hypocrisy. So without further ado, Brittany Antonacci, please come.
Thank you so much for that introduction. It's such an honor to be here today and be able to speak to all of you about one of the most important issues that's affecting New York State today, the issue of bail reform. So in 2019, New York State passed what we collectively refer to as the bail reform laws. So the bail reform laws signaled a complete overhaul of the criminal justice system as we knew it at the time. It triggered the immediate release of most incarcerated individuals at the time, most accused individuals at the time, pre-trial. The serious objections and concerns of district attorney's offices from across the state, from law enforcement agencies from across the state, were not considered in the drafting of these bail reforms. So what was the result of this? The result is what you're seeing right now in your own communities. The pendulum swung so far in favor of the accused that we are now seeing an uptick, a major increase in violent crimes across the state, an increased risk to public safety, to witnesses, to victims, and ultimately the result is that victims of crimes and witnesses of crimes are left choosing between pursuing justice and going forward with their cases or facing retribution and retaliation for moving forward and cooperating with law enforcement agencies and district attorney's offices. So, money bail and pretrial detention were virtually eliminated in almost all cases in New York State. So, effective 2020, New York State bail reform drastically curtailed cash bail and significantly reduced the number of incarcerated individuals pre-trial. Prior to bail reform, judges had the discretion to set bail on virtually any crime, misdemeanors, nonviolent felonies, and violent felonies. Today, that is not the case. Bail reform largely stripped judges' discretion. They no longer have discretion to set bail on the majority of misdemeanors, and they no longer have discretion to set bail on most nonviolent felonies. There are a few exceptions for both of those categories, but regardless of risk of flight, they cannot set bail for non-qualifying offenses. And that's what New York State did. They designated crimes into non-qualifying bail crimes and qualifying bail crimes. So you do have most violent felony offenses are still bail eligible in New York State, meaning that judges can set bail or they can remand pre-trial. There are two very important carve-outs that the legislature decided not to include, and that would be robbery in the second degree aided by another. So you and a group of your buddies could go up and steal an old woman's purse and you'll be home in time for dinner. You have burglary in the second degree. This probably affects mostly downstate or secured apartment facilities. If someone enters your apartment complex in the secure lobby area and they destroy it or they steal property out of it, they're going to be home in time for dinner. Judges have no discretion. They cannot set bail on those charges. So what's the result? Bail reform has tied the hands of judges. They don't have any discretion to set bail in most criminal cases. For bail eligible offenses, so we're now talking about the majority of the violent crimes and a few exceptions of misdemeanors and nonviolent crimes, the court must release the defendant. This is what the law says. Must release the defendant unless they make an individualized determination that that person poses a flight of risk to prosecution. So for example, they don't have ties to the community or they have several failures to appear on their criminal record. If the judge finds the defendant meets those factors and is a flight risk, then the law says they must set the least restrictive alternative and conditions that will reasonably ensure a defendant's return to court. Okay, so the judge says, well, I don't think anything other than monetary bail will make sure that this defendant comes back to court. The law says, great. Well, now you have to consider the defendant's ability to make that bail. You have to set bail in an amount that doesn't create an undue hardship to the defendant. So you essentially have to set an amount of bail the defendant can make. So the law now created different forms of pretrial bail. The court can set monetary bail, which is pretty standard, a secured bond, and then the court must offer an accused individual another option, a partially secured bond or a fully unsecured bond. So a partially unsecured bond, the defendant, family, friends can put up 10% in cash the amount of the bail. So if bail set at $200,000 because you're a flight risk, a serious flight risk in New York State, you have no ties to the community, all the defendant has to do is put up $20,000 in cash and have someone sign an affidavit saying, I promise they'll come back to court, I swear. And if they don't, I'll be responsible for the rest of that bond. The problem is, the court doesn't do any background check to make sure that that person can actually afford the rest of that bond, or that they have collateral that would support the rest of that bond. Unsecured bond, you don't have defendant, family, friends, doesn't have to put a dime down. So those are other options that the law requires judges to do. The courts are really pushing judges to get away from monetary bail and look at other forms of pretrial release. So other forms, we have supervised release, we have pretrial services. You have to call and check in with pretrial services once a week and say, hi, I'm still around, I know I have a case pending. Or you have enhanced court date reminders, travel restrictions, please don't leave this jurisdiction, limitations on firearms, and at a minimum, courts now have this new obligation. They have an obligation to remind defendants that they have to come back to court. So the preferred, in courts, when a defendant goes in for an arraignment, courts have to say, okay, what you, Mr. Accused, what is your preferred method of contact? So the court has to contact the defendant based upon their preferred method of contact, whether it's text message, first-class mail, phone call, whether they want an email reminder. And the kicker is the refusal to provide contact information is not a basis for the court to set bail on non-qualifying offenses, which again is most misdemeanors and most non-violent felonies. So if a defendant comes in and says, that's nice, I'm arrested on a couple non-violent felonies, I'm never coming back, I'm not giving you my email, you're not getting my phone number, not giving you my address, judges' hands are tied. They still can't set bail on those non-qualifying offenses. So what cannot be considered with setting bail for an eligible offense, meaning most violent felony offenses? Judges cannot consider the risk to public safety. That is not a factor that judges in New York State are allowed to consider. And New York State, I believe, is one, maybe two states in the entire country where judges do not have the discretion to consider a defendant's risk to public safety when determining whether bail is appropriate in a case. The only thing they can consider is, are they a flight risk for qualifying offenses? So here's another interesting addition to the bail reform laws. If a defendant does not show up for court, the judge has to wait 48 hours before the judge, he or she, is allowed to issue a bench warrant. You have to wait those 48 hours. Defendant gets picked. You wait 48 hours. Defendant gets picked up on your bench warrant. If it's a non-qualifying offense, the judge has to let the defendant go again. Okay, so you have the defendant arraigned on your bench warrant. They get released again. Next court date comes around. Defendant doesn't show up. Court has to issue another bench warrant. They get picked up again on that second bench warrant. Court has to release them. There's a new standard that says that in order for you, a judge, to set bail on a non-qualifying offense, the prosecution has to show that the defendant's failure to appear was willful and it was persistent. So we have to hold a hearing in order for a court to set any bail on a non-qualifying offense, even where a defendant doesn't appear multiple times. So I want to talk to you about a couple statistics that I found very interesting when preparing to speak to you all today. Applying the new bail reform rules to the approximately 170,000 arraignments in New York criminal courts back in 2019, approximately 84 of all new criminal cases would require mandatory release under the bail reforms as amended in 2020. If you want to break that down into categories, approximately 93% of misdemeanors and 87% of non-violent felonies would require mandatory release under these new laws. So that leaves only 15.8% of cases would be bail eligible. And as a result, the population held in New York City jails plummeted 40% from early 2019 to early 2020. That's according to the analysis of Office of Court Administration data for the Center of Court Innovation. I was reading a letter issued by the New York State Association of Chiefs of Police. Statewide, they represent approximately 400 law enforcement agencies across the state of New York. And some of the statistics in their paper were very interesting. So there's been statewide between 2019 and 2020, there's been an approximate 82% increase in shooting victims. There's been an 80% increase in individuals killed by gun violence. And more people were murdered in the year 2020 in New York State alone than they had been in over a decade. So you'll see Ann Donnelly, Ray Tierney. Bail reform is a huge issue in recent district attorney elections. So especially down on Long Island, you had a huge red wave. Ann Donnelly, Nassau County, ran a very strong anti-bail reform campaign. She ran against Todd Kaczynski, who she very lovingly referred to as Turn 'em Loose Todd. So she won that district attorney seat. Democrats have held that district attorney seat since 2006, or they had held that since 2006. Ray Tierney is the new district attorney of Suffolk County. He won his county 57 to 42%. Democrats have held the district attorney seat in that county since 2001. So this is extremely telling with how New Yorkers feel about the impact of these bail reform laws. I want to talk to you a little bit about implications with respect to bail reform. So judges have no discretion to set bail for drug offenses whatsoever unless it's an A1 felony. And let me tell you, in my small county, we're not getting A1 felonies at all. So virtually anyone charged with a drug sale or a drug offense is automatically getting released. That's a problem for a lot of reasons, because those, and I have Michael Chapman up here. He is an individual that I just prosecuted. He was mandatory release after he sold fentanyl-laced heroin to an undercover New York State trooper on 5 separate occasions. Mandatory release. While he was released, he sold fentanyl-laced heroin to another individual who took that heroin and he passed away. He overdosed. He's now charged and convicted of manslaughter, and he's now serving 9 years of incarceration. So public safety doesn't just mean violence. Those who go and sell fentanyl-laced drugs, which we're seeing it in cocaine, we're seeing it in marijuana, we're seeing it in all sorts of different types of drugs, that is a public safety issue. And it doesn't just have to be violent crime. I'm sure some of you recognize this individual from Wisconsin, Darrell Brooks, who had the very low bail set on him when he tried to run over the mother of his children, and he ended up killing 6 people during a Christmas parade. So that's just another example of why judges need discretion to consider, be able to consider the public safety aspect of the risk that a defendant poses to members of the public, to victims, and to witnesses and the community as a whole. So here are a couple examples based upon my experience in my small county, so you can imagine the impact that other district attorneys are experiencing across the state. Essentially, if the laws aren't reformed, you are going to have the decriminalization of a lot of drug crimes and a lot of larceny crimes, non-qualifying offenses. I had a defendant the other day, came into court, DWI. First time arrest in this state anyway. She had a history out of California. She's from California, she was up here visiting. She got in a car accident because she was drinking and driving, and she injured the passenger of the other vehicle. She goes into court and tells the judge, I'm never coming back. You're gonna have to get me from California, and you're gonna have to pay to get me. Okay, well the judge can't do a thing about it. The judge had to release that individual. Despite the fact that that person is an obvious flight risk, she told you she was. Financial crimes, we have people all the time who will sweep through the Walmart in our area or sweep through the other large stores. They'll steal thousands of dollars worth of property. They'll get caught, or they'll get caught later on, and they get mandatory release. They're not from our area, and we're never going to find them again. That's the fact. They're out of state, they're from different states, we're never going to get them. about a month ago. We had an individual walk into the bank, pass the teller a note, say, I have a gun, give me all your money. The teller gives him his money. He flees out, he gets caught, mandatory release for robbing a bank. He's not from here, he's from Arizona, we can't hold him. It's not a qualifying offense under the law, given those factors. Arson, same thing. You can go set an unoccupied car on fire. You can set 12 unoccupied cars on fire. You're going to get released. So these are just some small examples that I'm seeing in my county right now. I want to give you an extreme example, and it's just to prove a point, but I have a defendant arrested for bank robbery under the same facts I just set forth, sets multiple cars on fire. When he gets arrested by police, he's got cocaine, fentanyl, heroin all on him, and he decided to punch someone in the face while he was fleeing. So all of those charges are non-qualifying offenses. So he would have to be released. Despite the fact that you go in front of the judge and you say, Judge, he's got 6 failures to appear, he's not from the state, no ties to the community, and he has a prior felony conviction and 55 misdemeanor convictions. Judge has to let him go. So here's another issue with that. While he's released, he gets arrested for 17 misdemeanors, for stealing things, damaging property all over the place. I still can't ask the judge to set bail on my felony, because all those misdemeanors are non-qualifying offenses, and the only time I can ask a judge to set bail is if he commits another felony. So this same individual that goes to Monroe County and he does that same type of bank robbery, hands the teller a note, takes the money, and he flees. Monroe County can't ask the judge to set bail. He's released on Monroe County's charges. And then I have to do a hearing, try to find the guy, and ask the judge to revoke bail on my original felony. So it sounds convoluted because it is. There are a lot of issues that we have to really clear up, and these issues need to be looked at. Another issue is the cost of retrieving defendants for extradition purposes. A lot of times we'll get calls from states saying, we have this defendant of yours down in Arizona, do you want him? Well, if I want him, my county and my taxpayers have to pay for him. We have to get him back. So a lot of times we can't afford, especially in a small county, to run around the state or the country chasing these defendants. And the fact is, the people arrested of these crimes, people charged with these crimes, they know that. They know these rules, they know these laws, and quite frankly, often they get taken advantage of. We have situations where I have a felony drug defendant, he's arrested for selling fentanyl and heroin in my community. Clearly a public safety concern. He's got a warrant for a violation of probation for major drug trafficking in Ohio. So he gets released on my charges, he gets taken back to Ohio. Guess who has to pay to get him back from Ohio? We have to pay to get him back from Ohio. So it's just not possible in a lot of these situations. Discovery reform. This created, it's not often talked about, but this created a complete overhaul of how district attorneys and law enforcement have to provide discovery to defense attorneys and defendants. So discovery is basically the materials and information that's provided to the defendant by the district attorney while the case is pending. We have an absolute obligation to turn all that information over. We have to do so under very strict timelines. We essentially have 30 days after arrest to turn over all discovery. And this creates several issues. One, that time frame is simply not possible. It's meant for district attorneys' offices to fail. We don't have the resources to meet these very tight timelines. It would make sense to do somewhat of staggering discovery production. So here's the concern with this. What you're seeing is a major crisis in DA's offices. DA's district attorneys right now and assistant DAs are overworked, they're underpaid, the morale is extremely low. We are having a mass exodus of prosecutors across the state. Just like law enforcement in general, and I speak with law enforcement agencies, they're having a very difficult time retaining and recruiting. We're having the same issues. We are having a hard time getting experienced, talented prosecutors to stay, and a hard time recruiting. So the other issue issues with Discover Reform is we're forced to turn over sensitive information, witness statements, contact information at a very early stage in the game. So this is exposing the identities of witnesses and victims to defendants very early on, and it's having the effect of not benefiting the very people that bail reform was intended to help out, those communities. So it really does tie the hands of law enforcement, courts, and prosecutors. I used to be able to tell a witness, sit down with a victim and say, you're going to go in grand jury, this is a secretive proceeding, your name is not going to get out there if you cooperate with us. I can no longer do that. You are seeing huge cooperation issues across the state, especially in large cities where the threat of violence is real. It's a real threat to victims and it's a real threat to witnesses. And think about it. If you're there with your family and someone comes in and robs a restaurant and you're sitting there and you can ID the defendant, you give a description, you give a written statement, that statement immediately gets turned over to the defendant and to his attorney. And they have to, under New York state law, have to have the ability to get a hold of you. And quite frankly, even with your name, it's not hard to look up your phone number or address on the internet. Do you, as a citizen, want to risk that? You want to risk the safety of your family, of yourself, and that's even if you don't know the defendant. Think about the people in these inner city communities who know the defendant, who know their family, they know where they can get a hold of their family, can get them. Threat of violence is real and it's a huge problem. I want to talk to you a little bit, very quickly, I'm not sure how I am on time. Okay. Raise the age. Real issues with raise the age is that judges in family and youth court and criminal court are not allowed to consider a defendant's prior family court history. So you're going to have perpetual first-time offenders, and the judges are really not able to make informed decisions. So you have individuals who have a loaded handgun arrest, and finally they commit a robbery. The judge is not allowed to consider his prior to arrest. That needs to be looked at. And I'm just going to skip through because I want to get to this real quick. So this I just want to make you all aware of. The Clean Slate Act 2020 is coming up. It, I believe, is in the 2022 budget. It is right now in committee being reviewed. I had a very short opportunity to take a look at the bill as it's drafted currently. But CPL Section 16059 is on the books already. It was enacted in 2017. A person is eligible to apply for sealing of up to 2 misdemeanors and 1 felony and 1 misdemeanor of their criminal history, as long as you stay crime-free for 10 years. So you're allowed to apply for this. It's a process. You can't be on probation or parole. It doesn't apply to sex offenses or violent crime or serious felonies. Well, Clean Slate Act is a different game. Clean Slate Act, your entire criminal history is automatically sealed if you're crime-free from a felony for 7 years, from either the date of the conviction or your date of release, whatever is later. 3 years on misdemeanors, you cannot be on probation or parole. But here's the kicker, it doesn't exclude violent crimes or serious felonies. The good thing is that convictions are still available for law enforcement purposes and licensing purposes, but this is something you all need to be aware of going forward, that this is coming up. So I appreciate it, ladies and gentlemen. It's been an honor to speak with you all. I'll be available for questions out there if anyone has any questions.
I want to just say something first. You are a candidate this November for Cayuga County District Attorney. Everyone needs to know that. She may get removed because she's an acting. It's not the same as what we're trying to get the governor to do with Bragg. She is an acting district attorney, and as such, there is a quirk in the law which allows a gubernatorial appointment. It is literally never used. But then again, we've always said that Hochul is the Western New York version of Tammany Hall, law-proof. She is a candidate for re-election, or election, I should say, this November, and if you hear from her, you should return the call.